The U.S. Supreme Court is wading into a constitutional battle with the gaming industry. The state of California wants to ban violent video games to anyone under the age of 18. But federal judges have declared the law violates free speech, which is a First Amendment right. Susan Bonner is on this story this morning. She joins us now from Washington. It could be a landmark ruling. I guess the central issue of the court, before the court right now, Susan, is what?
Well, you know, it's a California law, essentially. The Supreme Court will rule whether the law is constitutional or not, but it will apply to more than California because many other states have tried to do what California did by passing a law which essentially criminalized the sale or rental of these violent video games to children under the age of 18. The gaming industry pushed back and pushed back hard. It spent several years in the courts, and the courts said that the law was in fact unconstitutional, that it violated the beloved right to free speech in the United States. And California said, no, we should be able to do this, as other states have tried and failed. And so it ended up before the Supreme Court. It's going to pretty much sew up a 5-year legal battle and answer the question that many states have tried to deal with for many years in this country, that many people believe these video games should be controlled in some way by the government.
Is it possible to summarize the arguments on either side, what both sides are saying in this case?
Well, sure. What the gaming industry has said is that, look, the entertainment industry is not controlled. You don't control music videos. You don't control movies. You don't regulate books. Children have access to this. Parents should be the one who say, I don't want my kids looking at this. I don't want them buying this. I don't want them renting this. It's not up to the government to do that. It's unconstitutional. But what the California lawyers have argued is that there's something different about video games, that because they're interactive, they do something different to a child's brain, potentially sparking aggression and violence. And they have argued before the Supreme Court that there is one exception that's been carved out to the First Amendment, and it deals with obscenity. There are obscenity laws that restrict a person's right to free speech, you know, in movies and videos and books, that if something is deemed obscene, people can't have access to it. And so they're saying that video games should belong in that category. There were interesting arguments made back last November before the Supreme Court, and the Supreme Court will issue its ruling, much anticipated, later on this morning.
All right, Susan, thanks. Susan Bonner in Washington.